Got be delayed. Good afternoon, everyone. I'm Divyansh, Rathi, managing partner at the Lexidem and Rathi law firm. I would like to welcome our viewers and distinct panelists to the webinar, Inauguration of Indian Dispute Resolution Center. Today, we are highly privileged to have with us as keynote speaker Honorable Justice A.K. Sikri, former Judge Supreme Court of India and International Judge, Singapore International Commercial Court. Welcome, sir. For the panel discussion, our distinguished panelists are Senior Advocate Mukhopadhaya, Supreme Court of India, Mr. Ratan K. Singh, Director, India Chartered Institute of Arbitrators, UK, and Founder India Society of Construction Law, UK. We have with us Mr. Samar Abbas Kazmi, Barrister at 39 Essex Chambers, London. I would express deep gratitude to our panelists for joining the webinar. The moderator for today's panel discussion is Mr. Shivam Jasra, Advocate, Supreme Court and Delhi High Court. He is alumnus of King's College London, where he pursued his LLM in International Dispute Resolution Pathway. The webinar is being telecasted live on latestlaws.com Facebook page. There will be a question and answer session at the end of the webinar, and attendees can send in their questions via the question and answer facility available on their screen. Now, I would like to invite Ms. Riya Rathi, Director and Head of Operations, Indian Dispute Resolution Center, to give a brief about the center.
Thank you, Divyansh. A very good evening to all.
Unmute.
Yeah. Thank you, Divyansh. A very good evening to all the esteemed panelists and guests who have joined us online. It gives me immense pleasure to present to you an overview of the Indian Dispute Resolution Center. The IDRC, established by a non-profit organization and first of its kind Institutional Alternative Dispute Resolution Center, which provides all the area components under one roof and umbrella. The IDRC provides a unique blend of both offline as well as online area platforms and infrastructure. We have state-of-the-art infrastructure for arbitration, mediation, conciliation, as also for early neutral evaluation and expert determination. Our IDEA centers are located at strategic commercial places in country with our head office in Keynote Place area of the New Delhi. Our indigenously developed IDRC e-ADR software provides end-to-end high-tech digital environment for e-arbitration, e-mediation, and e-conciliation. The e-ADR software has all the facets of 24/7 facility for e-filing of claim petitions, e-payment of registration and administration fees, issuance of e-notice to the party, holding of virtual hearings on certified state-of-the-art VC platforms, with options of virtual meeting in breakout rooms while the proceedings are underway. The e-ADR software also has the facility for digital signature and uploading of claim petitions, replies, and other miscellaneous applications and documents on secured cloud servers with 24/7 access to stakeholders and lawyers. The proceeding sheets are created, e-signed and saved online with auto-triggered sharing with the parties concerned. Let me give a brief tour of the website and the portal. In All About section, you can read about our vision project, apart from detail of our board of esteemed patrons and management team. We have a dedicated section for arbitration, which will provide an overview of the journey of arbitration in India, and also arbitration model clause, which can be incorporated in agreements and contracts as per Section 8 of the Arbitration and Conciliation Act 1996. You will also find indigenous IDRC rules 2019, which are based on Arbitration and Conciliation Act 1996, as amended up to December 2019, and on UNCITRAL arbitration rules. We have a panel of esteemed arbitrators, which include honorable former judges from Supreme Court, former Chief Justices of High Courts, former judges of High Courts and District Courts, senior advocates, advocates practicing in Supreme Court, High Court, District Court, and chartered accountants, architects, ex-bureaucrats, leaders from corporate world, from fields of education, real estate, pharma, hospitality, and like. In mediation section, you can find overview of the mediation in India, IDRC mediation clause, IDRC mediation rules 2019, and a panel of our mediators who have undergone 40 hours training provided by the Mediation and Conciliation Project Committee of the Supreme Court of India. In our conciliation section, you can find the details regarding appointment of conciliators and conciliation rules and procedures. In early neutral evaluation section, you will find the E&E rules and model clause and other resources. Likewise, in the expert determination section, you will find the rules, model clause, and other resources as well. The facilities provided by the IDRC include reception service, functional rooms, video conference, conference call, secretarial service, and library. The portal also has resource section with rich collection of Indian and overseas laws. Now, please allow me to share with you an overview of submission of arbitral claims and conduct of arbitration. The IDRC FAIADR portal provides for registration and login of 4 categories of persons and institutions. Registration of arbitrators and mediators is purely by invitations, while advocates, including law firms, and litigants, including corporations, can register themselves through simple process followed by verifications. To seek and invite, CV can also be submitted. Once registered, they get a personalized dashboard with all inbuilt facilities with 24/7 access. Finally, let me give a short overview on e-filing of arbitration claim petition and paperless conduct of arbitration. To e-file claim petition, advocates, law firms, and litigants, corporate entities registered with the IDRC can log into their personal dashboard. On the left column on the cases, you will find the options of file fresh case, file case, and cases as respondent. Now click on the file fresh case. Just fill up the requisite details and in metadata form and submit the same. You can check the entries in preview, and if needed, the corrections can be made. If data is found to be correct, press make payment. Software shall direct you to a third-party secure payment gateway for the payment of registration fees. Once the fee is paid successfully, your case will get registered and the IDRC e-arbitration software will assign an auto-generated case number to it. The option of uploading documents will get activated and you can upload digitally signed claim petition and documents on the IDRC cloud. Now IDRC will process your case, and if everything is found in place, your case will be assigned to an impaneled arbitrator for adjudication. Upon payment of administrative charges, the arbitrator will fix a date for hearing of the case and the proceedings will start. Now coming to the conduct of arbitration, impaneled IDRC arbitrator will log into his or her dashboard and open the assigned cases list. Arbitrator will open the specific listed case page and start online or offline hearing on the scheduled date and time. Upon conclusion of day's hearing, the arbitrator will enter the proceedings in the text box available in the portal and click Save Proceedings. Proceedings will be shared with the parties and advocates through an auto-generated email. Arbitrator will fix the next date of hearings with help of e-arbitration software. All the proceedings of the case will be available for perusal and download for arbitrator, litigants, and their lawyers in the case page. Upon termination of proceedings, soft copy of the entire file and proceeding sheets will be available for parties, and they will be provided duly signed arbitral awards as per the rules. This gives a broad overview of IDRC. Complete details are available on the idrc.com as well. Now, thank you for your hearing, and now I would request Honorable Justice Sikri to do the honors and declare the inauguration of the IDRC.
It's my pleasure to declare grand opening of IDRC, which is basically going to be online dispute resolution. So this opening is also online. So it's a great moment for IDRC and its team, and my good wishes to the entire team. And I hope that some institution now comes up in India which matches the international standards. So with that hope, and with those kinds of wishes, I say good luck to you.
Thank you, sir. Now I would like to ask Shivam to take forward the proceedings.
Well, good evening, everyone. I would like to thank Divyansh and Rathi for such a generous introduction, and thank you, Riya, for an amazing introduction of the Indian Dispute Resolution Center. It is certainly a great initiative towards institutionalizing the dispute resolution services like arbitration and mediation in India. And congratulations for that. Now, moving on towards today's panel discussion on ad hoc versus institutional dispute resolution, I would like to invite Senior Advocate Mr. Ciccu Mukhopadhaya, sir, to share his views on today's topic. Please, sir.
Thank you, Shivam, and Justice Sikri for inaugurating this institute. I also say hello to all those viewers who have joined us for this auspicious occasion. Coming then to one thing which I'd like to say at the beginning is I'm really pleased to find that a lot of hard work has gone into making this institution. I've gone through the rules briefly in the little time that I had, and I find it's quite exhaustive. One can see the hard work which has gone into making those and framing those rules, which is not an easy job. And I do wish, as Justice Sikri said, all the very best, and we always hope and wish for an institute of real caliber in India, and we hope that this will be the one. That takes me to the topic for the day: institutional dispute resolution versus ad hoc dispute resolution. And primarily I will concern myself with arbitration and what it involves, really speaking, between the two and the distinction in the short time that one has. These are subjects which have been debated for years, and people can speak and debate and argue against each other on the benefits or demerits and merits of each. And I think there is no sort of final view one way or the other. What really matters in any arbitration or mediation is the efficiency of the process. But over time, I think people have realized that institutional arbitrations do have some advantages over ad hoc arbitrations. What are those advantages for which people choose institutional arbitrations over time? Well, there are several advantages to it. The first and foremost, I think, in a country like India is that when you agree in institutional arbitration, you also agree the method of the constitution of the tribunal. That involves, normally in all these institutional rules, you'll have a system where the institution itself either fills in a gap where a sole arbitrator is to be appointed and parties are unable to agree. Or if there are three arbitrators, one party does not appoint the arbitrator, the institution steps in. You don't have to go in a section 11 as we do nowadays. The third is similarly for the chair in a three-member panel. If the two arbitrators are unable to agree, you go to the institution appoints it. It's a huge cost saving for clients, the users of the institution, who are most concerned with the whole process, because they don't have to go to court. They don't have to unnecessarily spend money on engaging lawyers to draft petitions, etc., as to, under Section 11, appear in court, and that whole process and the time that it takes. Despite the best efforts of our court systems, the clogging in the court does impact the time schedules in which such appointments are made. Although recently, at least in Delhi, we have found that it's been very, very quick compared to some other courts that we come across. The second biggest advantage, I think, is a set of defined rules, which is much more detailed than you have simply in the Act, for example. Each institution, of course, makes its rules, and by and large, now you find that most of the institutions have very similar set of rules, but there are always differences, not only in some of the rules, but also in the way they implement those rules. And I think a lot goes into how the institution itself functions once it starts. And I hope that the IDRC will make it their endeavor to make the functioning of the institution as efficient as it can be and as transparent as it can. There is, of course, a feeling in the arbitration world that many institutions have not been transparent in the past. For example, if there is a challenge to an arbitrator, the decisions earlier did not need to be, with reasons. The court would decide in the ICC, for example, but now they've moved from that. Not only are reasons provided, but they are made known. Transparency is an important part of any success of any institution. And we hope that the IDRC will also follow that process to make it a world-class institution. The advantage of the defined set of rules is that parties know in advance that there is a given step or given procedure to be followed. There are less surprises in the system, less options available for tribunals as well as the other party to try and derail the proceedings. With that is the fact that the institution itself is able to monitor the progress. One of the important, I think, benefits of an institutional arbitration is the ability of the institution to ensure that the process is ongoing, there are not unnecessary delays. And I'm not talking about there are arbitrations which are bound to take time, which you cannot say are delayed, but it does take time. But there are arbitrations which lag due to recalcitrance of one party or the other, or the tribunal itself at times. This is where the institution can step in and make sure that the arbitration progresses in an efficient and timely manner. These rules that I have seen have the 12-month window from the pleadings to complete. There is a 6-month further extension, and in extreme complex cases, the tribunal can extend it by another year. 2.5 years, I think, is normally reasonable for any arbitration process, even if it is complex, to be completed if it is efficient, unless, of course, there are guerrilla tactics employed by respondents, as they are sometimes. The next advantage is also quite a considerable one, particularly for users, and that's the fee schedule. Most institutions, as does the IDRC, have a set of rules which regulate the amount of fee that the tribunal would be paid, the administrative rules also. I note one distinction in these rules, that there's some leeway, I think, for parties to agree a separate set of their own fee arrangements, rather than just follow the schedule to the rules. But if they cannot agree, then of course the schedule applies. That makes it certain for a claimant as to what amount it will spend towards the arbitral process, apart from its own legal fees. In other words, the administration of the arbitration and the tribunal's fees, right from the day it wants to make its claim. It can therefore be assured that the fee will not exceed the highest fee that is possible under the rules. This is a very big advantage compared to various ad hoc arbitrations, particularly not only in India, I would say, but in many places of the world, where they go on for a number of hearings and the fees escalate because of one reason or the other. For the users, it is of prime importance that they are aware of what their liabilities are towards the arbitration process. This is one great advantage of institutional arbitrations, which IDRC will be able to offer, as I can see. There is one aspect which I heard in the morning from Riya, and which is that you have a panel of arbitrators. Whether or not institutions should have panel of arbitrators is also a matter of much debate. Party autonomy means that you should be able to select your arbitrators. You normally have, of course, forms which allow you to, which require arbitrators who are appointed to disclose various facts, including potential conflicts, availability, and of course, their own ability to carry on the nature of the arbitration task that is given. Those are checks and balances when the arbitral tribunal is constituted. If the panel is only so that parties are able to go to the site and just see who are available and get an idea of people there and then select whoever they want, but there is no restriction as to who the arbitrator can be in a particular matter, that is, you don't necessarily have to select from the panel, then having a panel is of no disadvantage. It is not a bad idea, I would say. But that is also can be viewed as an advantage by some people, that you don't have to start thinking in advance who should we look for as an arbitrator for this kind of a case. You go onto the site, look at the names of people, and ideas will come to you automatically as to who could be the ideal person to select as your nominee arbitrator or the sole arbitrator, or for that matter as the chair. If the two arbitrators have to select a chair, it would give them guidance too. I see a provision in these rules as to third-party disclosure for third-party funding. That's an interesting provision, because internationally, of course, it is now developed that if there is a third-party funder involved, it is required to be disclosed. And one of the salient reasons for that is there could be potential conflicts between the members of the tribunal itself. For example, if a member of the tribunal has advised a particular funder in some other matters, that would be a matter to disclose. And if, unless it is known as to who the funder is and the parties come forward and mention that, it may go unknown to the arbitrator concerned, disabling him from disclosing it, and you later don't want a situation where a challenge comes because of that. Third-party funding is a developing field in India. We have recent judgments which are seem to support it. There was a debate as to whether or not third-party funding should be permitted. I think there is nothing in arbitration world and even in litigation world, it is now more or less accepted worldwide that third-party funding should be available and is made available to parties who are willing to go into it. There are other advantages that I see in these rules, and that going with the times, the vast sort of network of e-services which are apparently available with the IDRC seem to be something which would be in keeping with the future of arbitration. A lot of people are saying that physical hearings are going to be less and less. I hope not, because I think there is still an advantage in a face-to-face interaction, especially when you're doing advocacy and especially when cross-examination of witnesses are involved. It's not that it can't be done by video conference, etc., but there is a certain element of, the immediate, especially the sort of demeanor of the witness, etc., which may not be as easy to see in a video conference as you would have in face-to-face where the witness is in front of you. But given the situation today, most hearings and literally all hearings, I think, are taking place to the extent that they can by video conferencing, and these services being offered by the IDRC are going to be something of moment. I don't think any other institute in India today is as equipped as the IDRC seems to be, and for that, my many congratulations. There is one other aspect of the arbitration and institutional arbitration, which I think in the past were more material, but now has become more accepted, and that is the confidentiality which attaches to arbitrations. Most institutional rules have in them the requirement of confidentiality. India did not have in our act, the 1940 Act did not have any such provision. The 1996 did not have until the recent amendment. So, but when you opted for institutional rules such as as you see in the IDRC rules also, confidentiality was very much an important part which played in the choice of the rules, because most people have opted for arbitration not only for expedition, but also for the reason that confidentiality is maintained in respect of the particular disputes that could have arisen. I think with that, I'm going to hand over back to Shivam to carry on to the next speaker. There is a question and answer session, I'm told, at the end. And once again, I would like to congratulate the whole team for the immense efforts that they have made, and wish it all the success that it can get. Thank you.
Thank you so much, Ciccu sir, for your enriching and insightful words. I am certain that it would enlighten and further help our young viewers on this subject. Now, I would like to request Mr. Ratan Singh sir to please share his experience on today's topic, especially in relation to his specialization in construction and arbitration disputes.
My Lord Justice Sikri, Mr. Mukhopadhaya, Samar, Divyansh, Riya, Shivam. First of all, I must congratulate team IDRC, and I echo the sentiments of my co-panelists, my Lord Justice Sikri, in saying that we see a great future for this IDRC, the way and with the enthusiasm and passion this IDRC has been brought into existence, the kind of rules you have prepared, and the foresightedness one can see in the rules. This is amazing mix of what one would look at in any institutional, in any arbitration institution. So I must thank the team, I must congratulate the team, and I wish and hope that we again meet next year to celebrate the anniversary of this IDRC, and we will have great caseload for the IDRC. Mr. Mukhopadhaya talked about institutional arbitration and talked about advantages in great detail. So since topic, the way it is phrased is ad hoc versus institutional arbitration, as my senior colleague, Mr. Mukhopadhaya, said that it is a old debate and there are pluses and minuses for both this form of arbitration. Let me start with my perspective on ad hoc arbitration to start. In my understanding, ad hoc arbitration is the natural and purest form of arbitration. If we see arbitration as a dispute resolution mechanism in its historical context, this is the purest form of arbitration. And so far as the institutional arbitration is concerned, it is a evolved form of arbitration where which is essentially a form where parties are assisted by a third party organization, that is the institution. What has happened and why it is that particularly in India, we all are talking about encouraging institutional arbitration. As Mr. Mukhopadhaya rightly said, it is our experience with ad hoc arbitration. What I have to say and to add to what Mr. Mukhopadhaya said is that yes, we had distortions in the ad hoc form of arbitration. And distortions were because of different stakeholders. But just because we had distortions, therefore, this form of arbitration becomes bad? My answer is no. This form of arbitration, that is ad hoc arbitration, is not a bad way of deciding dispute. It's not a bad form of decision-making process. In fact, there are certain jurisdictions where ad hoc arbitrations are getting bigger and bigger. In fact, I'll give an example of UK, where for a certain kind of arbitration, particularly maritime arbitration, you have the disputants and the consumers are more inclined towards ad hoc arbitration rather than institutional arbitration. Now, obviously, London, one may call it, and one calls it a Mecca of arbitration, and you have lots of institutional arbitration. You have institutions like FCIArb and so many other institutions. But still, so far as maritime arbitrations are concerned, people are still leaning towards, and they're going for arbitration. What I have to say is arbitration, whether it is institutional arbitration or ad hoc arbitration, has the stakeholder. Now, we are talking about institutional arbitration. I must say that today, globally, it has been recognized. It has been recognized in India. In fact, the high-level committee under the chairmanship of Justice Divyansh had done detailed analysis of this particular aspect. And after the thorough analysis of this on the subject, they came out with their view. They came out with their view that the ad hoc arbitration is not doing the way it should have institutional arbitration. Now, question would be, what is that we are looking at in institutional arbitration? and how institutional arbitration is really going to go. I would talk about 3 aspects. For me, quality of management of the institution, the governing body, the court of the institution, the credibility of the management team, neutrality of the management team, and reputation of the management team is the key. That is very important. One has to really be aware of this. Another very important aspect is quality of the case managers, the case counsels, the staff which are used by these different arbitration institutions. Now you can draw and you can just make a comparison between the case management teams and case counsels of ICC or some institutions we have in India. I don't want to name them. And you see the difference in the quality. And third important thing is quality of arbitrators. Now, quality of arbitrators, in fact, it is famously said that arbitration institution is as good as the arbitrators on the panel or arbitrators which they have in the database. Arbitrators, because most of the institutions are having their panel of arbitrators. Some of them are not having their panel of arbitrators. Some of them are having databases. Now, if you are having panel of arbitrators, the quality of arbitrators is going to decide the quality of your arbitration institution. Now, the kind of people you have in your panel, the kind of experience they have with themselves, the way you have selected them, whether you have got a specialist arbitration to deal with specialized subjects like construction disputes, oil and gas, merger acquisitions, sports or art arbitrations. Now, quality of arbitrators, and at the same time, we should be equally cautious and conscious with the fact that the way you choose the arbitrators for a particular case, the selection of arbitrators for a particular case is again very, very important. As Mr. Mukhopadhaya talked about transparency in the appointment of arbitrators, neutrality with which it is to be done. Please appreciate that institutional arbitration, the way it has evolved now, does not only play the role of administrator of the arbitration process. They do not only administer the arbitration, but they take many decisions. Now, threshold decision on jurisdictional issues. In fact, I had one arbitration going on in London under ICC rules. Now, there was a threshold challenge to the jurisdiction of ICC itself. No tribunal takes such decisions. Now, decisions on challenges to the appointments of the arbitrators on impartiality, on the issue of biasness or whatever. The issues, decision on jointness, decisions on consolidations. Now, these are decisions which has direct bearing on the outcome of the case. So, the roles which these institutions have taken upon themselves is not merely administrative. In fact, interesting aspect to this is that there have been many challenges in different jurisdictions on the due process issue whenever these institutions are being challenged with regard to the decisions they make on these threshold issues. So ultimately, the consistent view of the common thread in the decisions of all the jurisdictions has been that you agree to a particular institutional rule, and secondly, that the decisions which they take are administrative. They are not jurisdictional issue. These are administrative decisions. These are not jurisdictional decisions. So due process issues do arise, and they may arise, and even for that, I would say that IDRC has to take into consideration all of these issues. In fact, I just give you an example. I had one ICC arbitration. Dispute was whether machine supply for a sponge iron plant was defective or not. It was supplied by one Finnish company. Now, when when ICC had to appoint the chairman, ICC appointed one mechanical engineer turned Queen's Counsel. We can't find better arbitrator than this for a case like this, where ultimately issue was whether this particular machine was mechanically defective or not. So the way the considerations which are to weigh with the selection of arbitrators, and again that revolves around the kind of arbitrators you can have either on your panel or you can approach to. So this is something very, very important. In fact, I would say we have seen in India this problem of plenty so far as arbitrators are concerned. I'll give you an example of one arbitration institution in India, which is one of the oldest. Now, they have arbitrators which are in thousands and thousands. Every lawyer, every second lawyer is arbitrator, every second retired bureaucrat is arbitrator, every second honorable retired judges would be arbitrator, every architect, every chartered accountant. Now, there is no scrutiny. It is just that you have to apply and pay some fee and then you become arbitrator. No. The empanelment and selection has to be based on qualification, experience, expertise, not on subscription basis. In fact, 2014, I was speaking in a conference in London. There I had talked about default appointment before this amendment had come. And I had said, even with regard to the default appointments which are made by the courts in India, though it was India specific, I said that it will be really great if our courts will have a displayed list of arbitrators with their biodatas, the kind of fee they charge, the experiences they have, so that when matters goes to courts for default appointments, courts can encourage the parties to select from the list so that parties can own those arbitrators. So there will be, we'll retain that some element of autonomy of the parties. And then the party would say that, yeah, we have selected these arbitrators. The concerned arbitrator is fit for my case. Please appreciate when we talk about institutionalization of arbitration, one thing which is missing is that institutionalization, if we want to have, we will have to have a specialist arbitrators. In fact, what I would say, this is my personal understanding. In India, we do not have dearth of good decision makers, though we do have dearth of good international arbitrators who are really aware of the best practices of international arbitrations involved and all the developments which are going around. And we again do not have good specialist arbitration. As I talked about construction arbitration, which constitutes around 60% of big arbitration in India. ICC says in its report that around 40% of their arbitrations are construction arbitration. Now, difficulties, we do not teach construction law in law colleges. We don't teach construction law in engineering colleges. So where from we get that? For that, we need to create a better and better pool of arbitrators. And that is what my sense is. Now, what had happened in India is, intuitively, the moment parties had any dispute arising, the potential consumer of arbitration or the parties in India intuitively think about domestic arbitration. They do not think about institutional arbitration because they think that it is not meant for them, or there is nothing called institutional arbitration, or if there is any institutional arbitration process, it is not for us. It may be for international commercial arbitration, or it may be for some very big complex arbitration. And again, there were reasons for this. we didn't have good visible international arbitration institutions in India which could have been looked upon by the parties and the consumers. So it is really great to see that IDRC has taken this initiative, and they will be, I hope that they'll keep into mind all of important the thoughts which will come out from Milord Justice Sikri, Milord Justice Sikri has given you all the best wishes. Mr. Mukhopadhaya has given you all the best wishes from my side. There would be some challenges. You have to take care of this. If you talk about, so there are certain hardwares which are to be kept in place. There are some softwares which are to be kept in place. Now, we do not see any arbitration institution in India which has got breakout rooms for parties, caucus rooms for parties or for arbitrators. Now, simultaneous transcription facilities is something which we don't see in India. In fact, I remember once Michael Wong said that he was laughing at the way we do cross-examinations in our arbitration. He says, I saw question being corrected by learned arbitrators, and thereafter the answer is being given that is again being corrected by the learned arbitrators. Now he says, for me, it was something I never heard of, never saw this. So he, in fact, wrote in a paper, one chapter which was written in a book in the honor of Michael Snyder, his name in Europe. There he says, my message to all the arbitration arbitrators community is, don't go to India unless you have ensured that you have simultaneous transcription facility. Obviously, we are doing it. In fact, recently in 2 arbitrations in domestic arbitration seated in India, we had people coming from Dubai, and they did a very good job. So you have to take care of all of these things, and everything matters. People go to institutions not only to get administered their arbitration, but also for the help you render to them in facilitating the whole process. I think I should stop here. Otherwise, I'll be curtailing time of other speakers. Thank you very much for having me on this panel with such a distinguished panel. And I once again wish all the success, all the very best in your this endeavor. Thank you very much.
Thank you so much, Ratan sir, for putting forward your thoughts on today's topic. And one point raised by you was the express list of arbitrators. That was quite interesting, and I think all of us need to take a look at it. However, now I would like to invite Mr. Samar Abbas, who is a barrister at 39 Essex Chambers, to share his insights on today's topic. Please, Samar sir.
Thank you very, very much, Shivam. It's good to join all of you. I'm sitting here in London, and narrowly. This is the sort of event that might have been considered a bit tricky for someone from London to join. But one of the effects, perhaps long-term side effects of what the present situation is that as we are all being locked away in our own homes and offices and away from streets, we are able to connect with each other in a way that perhaps we weren't a few months ago. And so it's good to see all of you. Congratulations to the IDRC. When Riya walked us through the platform that you've got, it is, I have to say, not just leading in India, it is truly astoundingly wonderful what you've achieved, and congratulations, and all the best wishes to you. Now, one of the great benefits of being the last person to speak is that I don't have much to say which hasn't already been said. So I'll be hopefully not too long, and I know it's afternoon for me, and I could go on for a few hours, but it's evening for you in Delhi, so I should perhaps not go over time. I'd like to step back. Obviously, I practice in London. I've done a bit of work out of Singapore. I've had for and against Indian parties, but I don't have the perspective that's already been shared. So it's useful perhaps for me to to step back and look from the English perspective. And as Mr. Singh said, we are in England very much on one end of the spectrum. If you don't have an institution involved in administering an arbitration, well, that's quite unusual. And who are reluctant and tense respondents, but I've seen reluctant claimants as well. But people who are reluctant can take advantage of that. But as Mr. Singh says, it's absolutely right that ad hoc arbitration is the pure, genuine, original form of arbitration. And certainly when you look at concepts, when you talk about arbitration, you talk about party autonomy, you talk about the ability to choose your own flexible set of rules, your own arbitrators who's deciding your dispute. Those things, you can't get any purer form of that than an ad hoc arbitration. But if you step back and look at the question, and I don't see them necessarily being as antagonistic as perhaps the topic suggests. This debate is not unique to arbitration only. It's a debate that we have in all walks of life. Where does freedom end and the need for regulation arise? I mean, we are all seeing a good example of that in our daily lives nowadays. We could all be set free to walk around and roam the streets, and that would be party autonomy. But a society has decided, in different countries decided, well, you know what? There's a good reason at the moment for there to be a set of rules that regulate our day-to-day behavior. And I think that when institutional arbitration works, that it is. It is providing a framework for parties which have autonomously chosen an institution to say, well, you know what, we, the parties, decide that for this particular arbitration, for this particular dispute, we are going to be bound by the following set of rules. Now, that's the theory of institutional arbitration. In practice, as has been pointed out already, it ends up having the effect of limiting parties' choice in many ways. A lot of parties, especially respondents, find that it puts an unfair burden on them in terms of administrative costs, especially when a claim is not seen to be meritorious. Well, they say, well, you know what? We're being dragged into something that we didn't sign up for, and now we have to pay institution X, and I won't name any institutions. We now have to pay institution X all these administrative fees, and it's just a waste of time and money. I think that is a very fair criticism of institutional arbitration. But what I'd say is the institutions like the IDRC now, and institutions that are proliferating around the globe, are a good thing on balance. They are a good thing because they provide greater choice to parties. And nothing says party autonomy more than choice. Now, gone are the days when every arbitration which was administered by an institution was administered by the ICC or LCIA. We now have a number of very, very good institutions around the world, and it's not a one-size-fits-all type situation, which I think was one of the good, valid criticisms of the older institutions, shall we say. We have initiatives like yours. There are other institutions around the world that the parties can choose on a case-by-case basis. There's no one-size-fits-all solution. And so what you want when institutional arbitration works well, it works well in the sense of providing parties with a greater choice. Now, that's not to say that the drawbacks of institutional arbitration can be ignored, that it needs to be seen as the only solution, as I think as Mr. Singh has said quite rightly, that the party's ability to set their own rules and to be rid of administrative and other hassles is important. I think there are a number of arbitrations now where you end up having a hybrid approach. And I think a hybrid approach works well for parties. I think institutions need to be a little bit more respectful of the party's choice, and parties need to be a little bit more respectful of the need for a set of rules. So, an ad hoc arbitration administered under UNCITRAL rules, for instance, is a good example, something working well. It allows a flexibility, but at the same time, it does provide at least a framework of rules. So I think that's all I'm going to say by way of my main comments. But I think ultimately, it's not as much of a debate as perhaps one might say. There's a fine balance to be drawn between autonomy and chaos, and I think the right tools enable parties to choose. And I think there are a lot of sophisticated parties that are repeat customers of international arbitration, and they often decide. And I think the question which I put to the panel and to all of you is what do we say to up and coming companies that are not what's euphemistically called sophisticated users of international arbitration, that would like some guidance and a steer. And I think the IDRC provides a very good answer to many of those questions. But I'm sure there are other answers, and I'd be keen to hear thoughts. So I'm going to stop myself now. But obviously we'll have questions at the end. But once again, congratulations to all of you for a very, very good initiative.
Thank you so much, sir.
Thank you, Samar sir, for your enriching words. That was quite insightful. And now the time has come to invite your Lordship, Honorable Mr. Justice A.K. Sikri, to deliver his keynote address for today. Your Lordship, please.
Thank you, Shivam. And again, let me start by congratulating IDRC team for setting up of this center, to which I'll come later, that why I feel this center may do much better than other centers which have opened in India up to now. Before that, let us see, now we are discussing about this institutional arbitration versus ad hoc arbitration. And 3 panelists who have spoken, distinguished lawyers in their respective field, and in this arbitration, international arbitration. So therefore, in a way, I would say that they have said all and virtually everything. If I was sitting in a court and it was a judgment, I would have said at the end, I had the privilege of saying, I agree, and sign, and that would have been better. Because the very wonderful opinions are given the 3 persons on the bench. Having said that, and since we are webinar, so I have to say something. I would be collating the ideas that have been given by the 3 distinguished speakers, and try to approach the topic in somewhat different manner, but arrive in conclusions they have given. And in this entire scenario, what is the role which IDRC can play now? I will end with that. Let us start with the fundamentals, and which we talk and we keep talking in India today. Mr. Ratan Singh also mentioned about that Justice Shri Krishna Committee report, which was given, and this committee was set up in India. And what was the purpose? On the basis of the law is also amended in the year 2009, the latest, that it is recognized by now, and it is well-known fact that in India we have not been able to set up till date any institution of world repute. Because of that, so far as international arbitration is concerned, In India, it is really non-existent. The entire international arbitration disputes either are in SIAC or LCIA, ICC Paris, and all institutions. Of course, some now which have, as Samar also said, which are coming up in like Dubai also, and maybe Kuala Lumpur has also come a long way, Malaysian Arbitration Center, etc. But fact remains that even though there have been few institutions, we have FICCI ICA, which is there in existence for last 30, 40 years. But if you see, it is mostly catering to the domestic arbitrations. There was ICADR, which again could not do well insofar as arbitration is concerned, including even domestic arbitration. There were very, very few arbitration cases. For various reasons, we won't go into that. And likewise, other institutions which have again come up in last few years. In spite of all this, it is felt, and the government also realized, that we need an arbitration institution of an international repute. And for that, of course, they have gone a different route, and they want a particular institution to be set up, on which again there is a debate as to whether there can be an international arbitration institution which would win the trust of the international community if it is supported by a government, Indian government. So, or it should be an autonomous body altogether, without any interference and without any influence of the government. So that debate is there. But what I'm trying to say is that we have not been able to do it so far. And when it comes to arbitration culture, again, another aspect I'm saying is that what kind of arbitration culture is there in different countries. Again, as far as international community is concerned, they see India with some suspect. Now here the reason may not be the arbitrations in India, because as far as international arbitrations are concerned, they are not happening much in India. Ad hoc arbitrations are there, of course, because in a particular ad hoc international arbitrations, I am saying, because in a particular agreement, if it is said that the arbitration, the seat would be India, law would be India, because they, one Indian company and German company, they collaborate in India, and particularly in public sector, such clauses are there. And if the disputes arise, and even if Section 11 application is filed and it goes to Supreme Court for international arbitration, it is appointed ad hoc arbitral tribunal is constituted, and to that extent it is there. But here, when it comes to enforcement of the awards, again, it becomes a problem. And we have seen so many kinds of problems. Of course, in last many years, it started with enforcement, ONGC case, and then Bhartiya international cases, etc. Now that is history. But then thereafter, after Bhartiya International was overruled in sale judgment by the Constitution Bench in 2014, and in last for 5-6 years, there has been a very positive trend insofar as the judgments of the Supreme Court are concerned. But what I'm trying to say in this whole process is that in India, we still have to generate that kind of arbitration culture in which the international community has faith and trust. And we are able to attract international community in India. So even if those arbitrations which take place under the aegis of LCIA or IAC or ICC Singapore, ICC London or ICC Paris, etc., and suppose the award is given against the Indian party and ultimately enforced in India, they sometimes say that, look, now, although we have obtained the award, but it, insofar as judicial process in India is concerned, again, we do not know how much time it is going to take. So what I'm trying to say is, in order to bring arbitration reforms in India, we have to have, at 3 levels, these kinds of reforms have to be. First is the statutory regime. It should be such that the people laws are international compliant, and the provisions are, because today, why UNCITRAL came out with an model arbitration law. it was that in trans-border arbitration matters, as far as conduct of arbitration is concerned, right from the appointment of arbitration to the conduct of arbitration because arbitration is a hybrid system. It can't work of its own without the aid, at least, and support of the judiciary. So therefore, why not the laws should be almost same in all countries, so that one should not say that the arbitration process in one country is better than the other. Of course, in India, in 1990, that Arbitration Act was enacted, and I'm not going to take much time on that. Going by the experience and some amendment and the way the manner in which this Arbitration Act was interpreted in various judgments, etc. So it gave rise to some, it was thought that there's some amendments which are needed. So those amendments came in 2012, 15, and then 19, etc. What I think today is that as far as the statutory regime is concerned, we are in place, we have arrived. It is like nobody can find a fault in that, and particularly in 2015 amendment, where as Mr. Ciccu said about the, and Ratan Singh also mentioned about the independence of arbitrators and the choice of arbitrations, etc. So much is done now under these amendments, and the way these provisions are interpreted by the High Court, so that we are going in a right way insofar as choosing an tribunal and have a arbitrator which are totally independent and a good arbitrator. So the system is in place. Now, second thing which comes is the conduct of arbitration. Now here, conduct of arbitration, what happens here, as we know, the very essence of arbitral process is why people don't go to court, and particularly the commercial world, and why they want to, they prefer arbitration, which is an alternative dispute resolution mechanism, that there are many, many advantages of confidentiality, party autonomy, and they are, as the other speakers have said, they are able to choose an arbitrator. Mr. Ratan Singh emphasized a lot on that, going by the specialist arbitrators, that this is a particular dispute which needs a technical knowledge of a person who has to decide. So why not have a person, the technical person, as an arbitrator, which things are not available in the court process. So therefore, these are the advantages, no doubt about it. And that is why people still choose arbitration, and particularly commercial world. But at the same time, the commercial world, this is what I feel as a judge also, I have felt while dealing with the commercial cases sitting in the court, and as an arbitrator also, I feel that the as far as commercial world is concerned, it has its own expectations, it has its own way of working, and that is what it's not that we are deciding in favor, because both the parties are from the commercial world, so case can be decided in favor of one or the other. But whether we have been able, while deciding these cases, we have been able to sit on on their chair, and we are able to step into their shoes, and we are able to find out what are the requirements of the commercial world, and we have that kind of aptitude to decide those disputes. That is one aspect which the commercial world wants, and that is the legitimate expectation, I would say. Other thing is, which is stated by my all the other panelists, is that it has to be, and that is the very basic requirement of any arbitration law or arbitration process, I would say, is that it has to be effective, and it has to be not only cost effective but efficient also. Now here question is that the way our arbitration, ad hoc arbitration, have been going on, of course now the culture again has changed in last few years, thanks to the arbitration community. I would say all the stakeholders, because I remember when I, before I becoming judge in 90s, when I was practicing and would appear in these arbitration cases, it would be all those lawyers who are working in the court up to 4 or 4:30, and therefore the arbitration matter would be fixed before a retired judge. Mostly in those cases, arbitral tribunal used to be very less of 3 persons, a single arbitrator, some sitting in a 5-star hotel where the room would be booked, and it will start at 4 o'clock, 4:30 or sometime in the afternoon, and maybe after 1 hour or 2 hours, we would start looking at our watches, because at 5:30 or 6 we have to sit in our chambers and we have to work for the next day. We have to prepare for the court cases next day, because so this was, in nutshell, if I say, used to be treated as a part-time job for the lawyers who are there. But fortunately, as I'm saying, and I need not say it in detail, we have a robust arbitration bar now. We have person like both Ciccu Mukhopadhaya and Ratan Singh, I know, who are full-fledged in the arbitration and doing arbitration from morning till evening. And so therefore, this culture has changed significantly. It needs to be changed. But then many things which need to be done, and then it comes as far as the conduct of the arbitration process is concerned. They're both ways. Ad hoc arbitration has its own benefits, that the procedure adopted can be flexible. At the same time, this flexibility, in Indian context, the experience has been that sometimes it is delayed. Because of that, arbitration gets delayed when the arbitrators are also, their diaries are full, 3 arbitrators, they are sitting, and then the next date is to be chosen. Then it will sometimes, I've seen from my exam, that it will take at the end of the day at least 10 to 15 minutes in fixing the next day, which is suitable to all the 3 arbitrators also, and both the parties, where the lawyers on both sides are 2 or 3 lawyers, and all 6 lawyers also should also be give their consent, and the arbitrators should also give their consent. Now, this sometimes derails the process. So therefore, here I would say, from this angle, that the institution would be able to take care of much of this malice, and therefore we need an institutional arbitration. As Mr. Mukhopadhaya has stated, all those advantages of institutional arbitration over the ad hoc arbitration. And Mr. Ratan Singh has again said in a very almost same thing in a different manner, and in a given a very intelligible this scenario of all this. Yes, if there are certain benefits of ad hoc arbitration, but then those can be achieved by the institutional arbitration also, provided the institutions work in a particular manner. Like when he said about the, as I already said, about the specialist arbitrator, when he said about the panel of arbitrators which should be there, they should be of impeccable integrity, etc. Because from panel only, your the status of a particular institution, or how good or bad it would be judged, that the integrity and the quality of those arbitrators. So therefore, panel of arbitrators is also very, very important. And then he says that how the arbitration is chosen by the arbitral tribunal, by the institution in a particular case, where he said about the specialist, etc. And transcribers, again, which was a very, very important aspect which he said, which we are lacking in our country. So therefore, if the institutional arbitration, or a particular institution, is able to take care of these things, and is able to come up to the expectations of the stakeholders or the consumers of arbitration process, then it has the advantages in 2 ways. One, which Mr. Ciccu Mukhopadhaya has said it has, and supported by Mr. Samar also, who had stated in that manner. And number 2, that some of the advantages will be able of the ad hoc arbitration would be incorporated in the institutional system itself. As Samar very, he said in a very nice manner, the hybrid system. So when you have this hybrid system of ad hoc and institutional, that in the institution, you are trying to imbibe or trying to adopt and take away the take into consideration the advantages of ad hoc, and trying to put it into your system. If you do that, then according to me, institutional arbitration may help in so many ways. And in a country like India, where we are today, as I said, started in the beginning, don't have international arbitration at institutional level as of today. There's no institution so far I have seen in India which has been able to generate international arbitration work. Ad hoc arbitrators, appointment, etc. is there. Therefore, institutional arbitration may be required for that angle, and India needs it. Now, IDRC, coming to this institution, why I said in the beginning that I have great expectations and I wish you good luck, 2 or 3 things. Number one, this is one institution I am finding which is now established by very, very young enthusiasts. Normally, such institutions are wherever the other institutions are there. Of course, those which are established by those who have very good experience in arbitration and international arbitrations. So that is it. That is their own advantages. But young blood coming, a totally new approach, and full with enthusiasm, technologically much more savvy than our generation. All those advantages are there because you can go a long way. You cannot only wait for quite some time, but then but yes, you have to have some patience because you will not be able to have the success overnight. And that too, as I said, keeping in view the atmosphere in India insofar as international arbitration is concerned. It's a challenge, it's a big challenge. Then it's like a startup by a young group, and you can take up. And you have started, second aspect which I'm saying is that you have started on a very positive note. Certain facilities which you have provided here and some out-of-box thinking which you have given in establishing that IDRC for, want of time now, I don't want to repeat that, but Riya has already taken through and given us the tour of this center and has stated so. And so these facilities which you are going to provide with end-to-end this digitization and totally paperless, etc. And COVID-19 has taught us that this is the future. And this is the future. It may not be as far as courts are concerned, because court physical hearing would be required. We'll have to go back. But then even in court system, I am saying always that, look, we have learned from this that like in Delhi High Court, we have paperless courts, e-courts, 10, 12 courts. We should have now in future 2 or 3 at least dedicated video conferencing courts where the hearing it can be facilitated through video conferencing, where physical presence is not possible due to some reason, not because of COVID. Even that situation is over. But we can save a lot, and this technology can lead to, insofar as courts are concerned, better case management and court management, and we can lessen the burden of arrears, etc. So same thing if it is applied in an institution, not only the conduct of arbitrations would be much more efficient, but would be cost effective also. For that reason, I see great scope in IDRC. And I would again say and repeat, yes, it's a big challenge. It's not an easy job. You'll have to work day in and day out. You'll have to burn your midnight oil, as it is said. And as Samar very rightly said, that I finish with this, that it's not that one size fits all. Ultimately, when an agreement is entered into between the parties, I'm talking of collaboration agreement, business arrangement. At that stage itself, it is decided that if disputes arise, how they will be settled. And that is why arbitration clause is provided in the contract itself. So going by those, the parties would decide in a particular case whether they want an ad hoc or they want an institutional arbitration. They would come to know. And institutional arbitration, such a clause in India would be there only if there are institutions which are trustworthy. So therefore, for that, again, I would say my good wishes to you, and let us hope for the best. Thank you.
Thank you so much, Lordship.
Thank you so much, Your Lordship, for your words of wisdom on today's topic, and especially thank you from the IDRC team for boosting our confidence. We'll surely work hard for making it a big success. Thank you so much, Your Lordship. Now I would like to invite Divyansh to take charge from me and start the question and answers round. Please, Divyansh.
Thank you, Shivam, for managing the panel discussion. My first question is for Lordship. That India improved 101 slot World Bank's ease of doing business report 2020 from 162 to 61. But in last years, we are still at lowly 161 in enforcement of contracts. What is the way forward as Commercial Courts Act 2015 not helped much in this aspect, Lordship?
I tell you, I think I was talking to your father, somebody who gave me that information yesterday, that he was talking to somebody, I think maybe Samar only or somebody. And in England, what is the position? They say that most of the arbitration work which they are generating is international arbitration. And there's not much, Samar would be able to confirm it, not much arbitration insofar as domestic arbitration is concerned, because that is taken care of by their commercial courts. So the commercial courts are so efficient in that country that as far as the commercial disputes within the country are concerned, they are able to take care of that. So that is what is needed. And if we, when we come to the enforcement of the, as you said, the contracts, and if we want to really have our ranking improved, enforcement of contracts is one, criteria which is very, very important. And for that, as I only indicated at that time, when even international awards are passed and they come for enforcement, and they have to be enforced as speedily, as efficiently as possible. So in that process, the commercial courts can play a very, very important role, I would say.
Can I just pick up one point on that, which is agree entirely with Justice Sikri. There's often a discussion about litigation versus arbitration, as if they are competitors. But in fact, they complement each other. They must complement.
Yes, I entirely agree. I entirely agree.
And the benefit that we have, without saying what works in England must therefore work everywhere else, and certainly not the intention. But one of the benefits that we have, and it's a benefit that Singapore has now with a dedicated commercial court and dedicated international commercial court,
yes,
is you have two streams where parties can go for their disputes. And one of the difficulties that you have in a lot of countries, and it's not unique to India, it's a lot of the world, is it's seen as antagonistic between litigation and arbitration. And the arbitration lawyers say, well, no, you must do arbitration. And litigation lawyers say, no, you must do litigation. Whereas where it works, and the only way to make it work is for them to complement each other. So that's the only thing that I would say on that.
No, you're very right. And that I know now, I have the experience as far as Singapore is concerned, because I am the judge in Singapore International Commercial Court. I have seen that. So how SIAC and SICC, and even I would say today mediation, when that steps in, SIMC, how the three organs are complementing each other, it's a really, an example which everybody should emulate. The way they function, complementing each other. It's not that one is as you rightly said, in competition with others, or this is this versus that. But then they say that, look, these are the advantages of in each system, and you have a good choice. We give you the entire choice, and it will depend upon as far as the stakeholders or the consumers are concerned, that in a given situation, whether it's going to SICC suits them or going to SIAC suits them, or they should go to the mediation first and they should go to SIMC. But the three organs or three institutions are working in tandem, which I have seen myself.
Thank you, Lordship, for your thoughts on this question. Thank you, Samar, sir. My next question is for Ciccu, sir. The question is by Nidhi Sharma. She has asked that high cost of dispute resolution in arbitration is looked upon damper on choosing it as a method of dispute resolution. So how to handle the cost issue in arbitration proceedings?
I think one of the answers to that question is institutional arbitration. You can handle the cost issue quite well by choosing an institution which has defined rules for costs. And given that IDRC has just started, maybe that's one way forward for it.
Thank you, sir, for your answer. My next question is for Samar, that the court interference in arbitral proceedings is always a debated issue. So what's your take on it with respect to UK and third world countries?
Well, listen, I think, I mean, I've just touched upon part of that question. I think there's a chicken and egg problem. You need courts to be able to support arbitration for arbitration to work properly. And when arbitration works properly, then courts are less crowded. So that ends up being a problem, and this is a problem that you have in a lot of countries. I think, I mean, without going into perhaps too much contentious detail about how the profession operates and goes into senior levels and judicial appointments, I think there is a strong case to be made in every country for there to be specialist courts, specialist judges who have practiced at the bar in that area. So to take the example of construction, as Mr. Singh said earlier, you don't do construction law at university unless you do an LLM in some very few areas. And so if you've just had generalist practice and you're sitting for the first time on a construction matter, you will struggle. And so the solution that we have in the UK, for instance, is that we have a specialist technology and construction court. And the judges for the technology and construction court are drawn from the construction bar. And those are people who made their careers out of practicing at the construction bar. So I think that's one way of perhaps squaring that circle. I'm sure there are other ways as well. And different jurisdictions will have different views on appointments to courts, etc. I think at a basic level, you need to start with greater institutional support from the court system in each country, and I think that's got to be the starting point to the extent there is a starting point.
Thank you, Samar, for your on this question. My next question is for Ratan, sir. So that Justice Sri Krishna Committee talks about arbitration of India. It has been seen that in the procedure, it influences upon freedom of arbitration, where the courts are involved or the government is involved in deciding who will be functionaries of Arbitration Council of India. What is your opinion, the amendment that has been made to provide for Arbitration Council of India?
Thank you, Divyansh. I have two thoughts on this. One, arbitration institutions are service providers. Whether it is commercial courts, like in Singapore, where Moderate Justice Sikri is sitting as a judge, Singapore International Commercial Court, they are all service providers. This is how we have to look at them. Now, how you provide your service, you cannot force parties to go to you. How you understand your role as an institution. Institutions, arbitration institutions have assumed a lot of roles. Now, how you take your role is an important aspect. Now, so far as this Arbitration Council of India issue is concerned, in fact, Moderate Justice Sikri also referred to this, some of it. I would say that this is again chicken and egg situation. If governments support any institution, not only it starts the whole process, starts the ball rolling, two, it gives credibility as well to that institution. But then this comes with the other side of the story, that is a criticism that this institution is supported by government, and government in any jurisdiction would be a big litigant. Now, for this solution, I can suggest is the CTEC approach. If you see CTEC, C-I-E-T-A-C, which is the most popular arbitration institution in China. Now, CTEC was brought into force and in fact supported by government. But then it was allowed to go independent financially or otherwise. Please appreciate, financing a particular institution to start and allowing that institution to run independent of the government or the organization which finances it are two different issues. We cannot say that if you will have in ACA world's top class reputed arbitration professionals sitting in the management, can you say that just because government funded that particular institution to come up with will really have any impact on this? I'm sorry, we can take care of this. It is a delicate balance, yes, but it needs some impetus, it needs some a push which is needed from the side of the government, but it has to be allowed to be independent, and there we have to work consciously. So if you have got top names from all across the globe sitting in the management, in the management committee and the court, obviously I would say it will mitigate at least the concerns which are being brought about this. Yeah.
Thank you, sir, for your thoughts on this question. The next question is for all the panelists for a quick comment. The issue of what can be a few actionable points on improving India's rank in enforcement of contract in World Bank report of ease of doing business. I would like to start with Samar, sir.
There's only one answer, which is you improve it by improving enforcement. That's there's no, it's a black box answer. It's not an answer which there are steps that you can take, but you need to improve a number of things. But as I said earlier, the starting point is increasing willingness to support. Now, there will be decisions that go wrong, right? So, can I speak again? Speaking from an English perspective, we have Section 69, which is appeals on points of law. Now, most institutional rules exclude Section 69. Some ad hoc arbitrations, ad hoc arbitrations don't. Some institutions don't. We have this week had one Section 69 appeal succeed, and that was in the news. So an appeal on the point of law, a challenge to an arbitral award, succeeding on a question of law makes news here. Now, if I'm sure there are many arbitrators who get some things wrong, who make mistakes. But I think if you are to support enforcement, if you are to support arbitration, you've got to say, well, you know what, when parties choose arbitration, you don't want respondents or the unhappy party at the end of the arbitration to be able to throw a spanner in the works. And I think some jurisdictions are seen to be more pro-spanner in the works than pro-enforcement. And I think that perception needs to change and that reality needs to change. I think that's all the answer that I think I can give at the moment.
Thank you, sir. Ratan, sir, what would be your thoughts on it?
My answer, I would say the thumb rule would be, and the best answer would be, the time taken by the courts in deciding the issues which are coming before them. We have taken care of this time issue so far as arbitration is concerned by way of amendment. But ultimately matters travel to courts. Though we have timelines under Commercial Courts Act or even in CPC, but we need to work more on this. If we work on this, I think we can clear this.
Thank you, Ratan sir. Ciccu sir, what would be your words of wisdom on it?
I think yes, the two aspects which can go a long way. One is what Ratan just said, time frames. I think there has to be odd challenge time frames. I mean, I'm not on the question of the scope of 34 or things like that, but just simply the time frame for deciding. And maybe one way that it can be dealt with is like in England, you have deputy judges, QCs, senior counsels, the QCs who can act as deputy judges in the first instance, can decide these matters, and then it can, if parties think it has to be appealed, will be appealed. That would take some pressure off the, the court itself in deciding these kind of matters. The other is, of course, when you're talking about enforcement of contracts, is to limit, as Samar said, I think, the scope of interference. As awards get interfered more and more, there will be more and more challenges and more time frame, time will be lost in those processes. 34 has been narrowed down in words, but even today it seems to be broader than Section 69 of the English Act. If you look at Section 69 of the English Act and 67, 68, 69, they seem to be much broader in terms of words than what we have in our Section 34. But in practice, it is much narrower. These are the two aspects I think where we can improve.
Thank you so much, sir. I would like to ask our panel if they have any final comments before we end this session. Any thoughts or suggestions?
Yeah, I would only add only one thing to that, or rather two things. If we have to achieve what all the three speakers have said, and rightly so, I entirely agree with that. The reforms at two levels are needed. One, if we want early disposal, there has to be the time for which the lawyers have to argue has also to be rationed. So it should not be an unlimited hearing, as Mr. Ciccu has rightly mentioned, that although our scope of Section 34 is much narrower than Section 69 of the UK Act, but here the arguments go on as if it is the first appeal now, and in spite of knowing the limitation, it goes on like that. And the lawyers don't finish the arguments for days together. Second most important thing which the administration of justice has to take care, and I'm always of the view, when you have to, of course, that is not a good thing for us, since I also belong to Delhi High Court. I was that is not, at least in Delhi High Court, has taken care of that, which others also should take care, that on in commercial courts or those dealing with these matters, those judges should be well equipped in this branch of law. We need specialist judges to decide these cases, who have not only good knowledge of commercial laws, including arbitration, contracts, etc., and but also uptake is really good. And because in India, the judges, we are journalists. We are supposed to sit on all jurisdiction. In 20 years of my judgeship, I have done all kinds of matters which are there. But then every judge has its own some area of specialization. And in commercial matters, if we have those judges with commercial bent of mind, the uptake would be so good if a judge other judge who may decide that matter in 2 days' time, and one good judge with that may decide in 1 or 2 hours' time. So that may also do. So these two aspects need to be taken care of.
Thank you so much, Lordship, for pointing out very pertinent points of specialization among judges who are sitting in the commercial courts, and also the amount of time the lawyers take in arguments, as well in their length of the written arguments also should be reduced so as to make the readability for judges less, the reading time.
Video conference hearing may take care of this problem.
Definitely. So with this, I would like to come to end of this session. I would like to thank Justice Sikri, Ciccu Mukhopadhaya sir, Ratan sir, and Samar Abbas sir for sparing time out of their busy schedule to join us for the inauguration and today's webinar. I would like to thank our IT head, Mr. Manoj Sharma, and his team for all the hard work he has taken to develop the website and software for IDRC. I would like to inform that if the viewers want to know more about IDRC, they can visit the IDRC.com or contact us at info@theidrc.com. With this, we would like to end this session. Thank you, everyone. Thank you for inaugurating this session. Thank you, Lordship. Stay safe and stay at home. Thank you. Thank you, Lordship.
Thank you. Best of luck again.
Best of
Thank you, Your Lordship.
Good luck and thank you, everybody.
Thank you. Good luck.
Thank you.